Jane Clough did what she was told to do. She reported the father of her child for rape and handed the police photographs she had been keeping for a year. 9 charges were brought. Then a court let him out and told her there was nothing to be done about it. Not by the police. Not by the prosecutors. Not by her. She wrote in her diary that he would come for her. 7 months later he was waiting in the car park where she worked. This is what the court was told, what it was not told, and why the law that carries her name still would not have saved her. John and Penny Clough married in December 1978. Their second child, Jane, was born about 5 years later, in Nelson, in East Lancashire. She had an older brother, Peter, and a younger sister, Louise. Both of them have said the same thing about her since. When something went wrong and they did not want to take it to their parents, they took it to Jane. She did well at school. Her mother was a nurse, and Jane followed her into it. She qualified in 2007, aged 22, and took a job in the Accident and Emergency Department at Blackpool Victoria Hospital. The people who worked with her describe someone who was good at the parts of the job that cannot be taught. Colleagues have called her what a nurse should be. A psychologist who later reviewed the case for a television documentary put it a different way. The caring was not professional, she said. It was vocational. Jane volunteered. She gave up time she did not have. She was 23 when she met Jonathan Vass. He worked in the same hospital, on the ambulance side. He was a few years older, 6'3", and built. Outside work he did shifts on the door of a nightclub. He was also married, with 2 young children. Jane did not learn that for several months, and when she did, he told her the marriage was ending. It was not. For most of their relationship he moved between 2 houses, and neither woman knew about the other one. Her family noticed things before she did. He told stories that did not hold together. A grandmother with a house in London. An inheritance. Money that never arrived, in a man whose credit cards were at their limit. Small lies, about nothing in particular, told to people who had no reason to be lied to. Her parents have said it was not any single lie. It was that there was no reason for them. Then came the calls. Where she was. Who she was with. What time she would be back. If she went for lunch with colleagues he would find out where, and he would appear. The violence began during the pregnancy. The marks were where clothing covered them. Jane wore long sleeves at work, and then scarves, and a colleague noticed the scarves before she noticed anything else. Jane went to the police once, early, and then decided not to take the complaint forward. Her family have said she stopped because of what a conviction would do to his career. She kept the photographs. Her daughter was born in October 2009. 6 weeks after the birth, on the 29th of November 2009, Jane telephoned the police and alleged that Vass had raped her. She made statements over several sessions across several weeks. Officers took her through the same accounts repeatedly. Her account did not change. She gave them the photographs she had kept for a year. Jonathan Vass was charged with 9 counts of rape, 1 count of sexual assault and 3 counts of common assault. He denied all of it, and told police that Jane had invented the allegations to damage him. None of those charges was ever tried. That matters for everything that follows, and it is why every reference to them in this film is a reference to an allegation. He was remanded into custody. Her family have described that week as the first time in 2 years they had slept properly. He was somewhere she was not, the trial was coming, and Jane had agreed to give evidence. In December 2009 there were 2 bail hearings, 8 days apart. Both were held in the private chambers of Judge Simon Newell. That means no public gallery and no press, which is ordinary for bail applications in the Crown Court. It is worth pausing on that, because it shapes everything that came afterwards. A bail hearing decides whether a person accused of a serious offense goes home tonight. It is one of the most consequential decisions in a criminal case, and it is routinely taken in a room nobody can watch. There are reasons for it. Bail hearings are quick, they deal in allegations that have not been tested, and reporting them could prejudice a trial that has not happened yet. The consequence is that when this decision was later questioned, there was no public record of it to question. For 18 months, Everything anyone knew about those 2 hearings came from statements issued afterwards by the institutions involved. The first hearing was on the 3rd of December. The prosecutor was Roger Green, and he opposed bail. In that hearing, Green referred to something that would not come up again. Vass's wife, Joanne, had reported him for domestic violence at some point in the past. Nothing had come of it. No proceedings, no charge. Green told the court it might nevertheless be relevant to the allegations Jane had made. Bail was refused. The second hearing was on the 11th of December. At that hearing, the earlier report was not mentioned. By then Joanne Vass, and another woman with whom Vass had been in a relationship, had both sided with the defense. The transcript records them as horrified at the suggestion that he was violent. His barrister, Andrew Nuttall, told the court that Mrs. Vass's statement gave no indication of any violence towards her. Vass had no previous convictions. Whatever the police believed about him, on paper there was nothing. Judge Newell granted bail. The conditions were that Vass live at a specified address, that he have no contact with Jane, and that he not enter the boroughs of Burnley and Pendle, where she was staying, except to attend court or to see his solicitor. He walked out before Christmas. The trial was listed for October. To understand what happened in those 2 rooms, it is necessary to understand what the judge was working with. Bail in England and Wales is governed by the Bail Act 1976. The Act begins from a presumption. A person charged with an offence is entitled to bail. The court does not start from the question of whether to let someone out. It starts from the position that they go out, and then asks whether an exception applies. For an offence punishable by imprisonment, the main exceptions sit in the first schedule. A court need not grant bail if it is satisfied there are substantial grounds for believing that the defendant, if released, would do one of 3 things. Fail to surrender to custody, commit an offence while on bail, or interfere with witnesses, or otherwise obstruct the course of justice. Those are the 3 doors. The prosecution has to get through one of them, or the defendant goes home. And the threshold matters. The test is not whether something might happen. It is not whether the court has a bad feeling about the man in front of it. The Act asks for substantial grounds for believing, which is a real standard, and it has to be met with material the court can point to. Suspicion is not enough. Nor is the seriousness of the charge on its own, however serious it is. That is deliberate. A system that refused bail whenever refusing it would be safest would not be a bail system, and most people who are charged with an offence have not yet been convicted of it. The presumption exists because the alternative is imprisoning people on the strength of an accusation, none of which tells you whether the right decision was made in this case. It tells you what had to be argued, and by whom. The prosecution went at door 1 and door 3. He will run. He will get to the witnesses. Both were rejected. Door 2 is the one that says he would commit an offence while on bail. It is there in the statute. It is the door that covers the risk of him hurting her. Nobody walked through it. And this is the part of the case that is hardest to sit with. It was not overlooked. The Crown Prosecution Service did not choose to oppose bail on the ground that Vass might commit further offences. That option was open to them. They did not use it. Years later, the chief Crown Prosecutor for the area, Ian Rushton, explained why. Rape suggests violence, he said, and in their view the court was made fully aware of the allegations and of the risk that Vass would try to contact witnesses. He said counsel had made that clear, and the judge then had a difficult decision to make. He also said something that does not appear in the transcripts at all. The barrister had met the police before the hearing and was fully up to speed on the fears they held. Those fears were, in his words, implicit in the objection about witness interference. That was the provision of the Bail Act they had to hang their objection on. Read that carefully, because it is the whole case. The people in that room were worried that Vass would hurt Jane. That worry was real, and it had come from officers who knew the file. But when it was translated into a legal objection, it went into the box marked witness interference, because that was the box that was available to them. The judge heard an argument about the integrity of a trial. Nobody put an argument to him about the safety of a woman. There is a difference between a man who is a danger to a case and a man who is a danger to a person. The Bail Act asks about both. In December 2009, only one of those questions was ever put. There was one more thing about that hearing, and the family would spend the next 2 years arguing about it. There was no way to test the decision. If a Crown Court judge granted bail, the prosecution could not appeal it. Not to a higher judge, not to a different court, not on new information. The decision was final at the moment it was made. An appeal route did exist. It ran in one direction only. A defendant who was refused bail could appeal. Vass had done exactly that. He had been refused on the 3rd of December, and he came back on the 11th, and the second time he was released. There was no equivalent route for the Crown. There had been one since 1993, but it applied only where a magistrate's court had granted bail. If a magistrate had made the same decision on the same morning, the prosecution could have gone straight to a higher court and challenged it. The reason the decision stood was that it had been made by a more senior judge. So the position, in December 2009, was this. The man accused could ask twice. The woman accusing him could not ask once. Jane did not go home. She moved into her parents' house with her daughter. They fitted extra locks to the front and back doors. She stopped going anywhere by herself. When she drove to work, a colleague came out to the car park and walked in with her, because the distance between her car and the hospital doors was long enough to matter. Her family describe a house organized entirely around the movements of a man who was 50 miles away. Vass had lost the rest of his life by then. His wife had learned about Jane while he was on remand, because a month's absence cannot be explained. She put him out. He moved back in with his parents. In early 2010, Jane started keeping a diary. The entries run across months, and they circle the same problem. He is going to be convicted. He knows it. There is a gap between now and then. In March, she writes that she cannot help thinking he will get his revenge on her. She writes about what plan he might be forming. She writes that she does not believe he will simply sit and wait for a jury. Later she writes about the possibility that he will kill her, and asks what would stop him. She was not the only person who thought it. At some point in those months, Vass told one of Jane's colleagues that if he were convicted, he would kill her. The colleague treated it as bravado. It was not passed on in any way that reached a court. And there was nowhere to take it. The bail decision was closed. In May, Jane went back to the police and made her formal victim statement. It would be the foundation of the prosecution case, and it meant she would stand up in October and be cross-examined about the worst thing that had happened to her. She said she would do it. By July, she had been living like that for 7 months, and the fear had begun to loosen a little. She stopped asking colleagues to meet her at the car. On the 23rd, she went out with friends from work for the first time in years. They have said she seemed like herself. On Sunday, the 25th of July 2010, at around 7 in the evening, Jane left her 9-month-old daughter at her parents' house and drove to Blackpool, Victoria for a night shift. Vass was in the car park. He had been there for some time. She was attacked about 100 yards from the main entrance. She was carried into the accident and emergency department. The people who tried to save her were the people she worked with, and they did not know who she was at first. She was identified by the name badge on her uniform. Jane Clough was 26. Police were at her parents' door before midnight. Armed officers were posted outside the house, because Jane's daughter was inside it. At around 6 the following morning, Vass drove to that house. Officers were waiting and arrested him in the road. In the boot of his car they found matches and full cans of petrol. On the 7th of October 2010, at Preston Crown Court, Jonathan Vass pleaded guilty to murder. A week later, on the 14th, Judge Anthony Russell QC sentenced him to life imprisonment with a minimum term of 30 years. He described the murder as brutal and callous, and said Vass had shown no remorse. And then he ordered that the rape charges lie on the file. A count that lies on the file is not tried, and it is not withdrawn. It sits there. It can be revived only with the permission of the court, and in practice that does not happen once a defendant is serving a life sentence for something more serious. The reasoning behind it is ordinary and, on its own terms, sound. Vass had pleaded guilty to murder. A second trial would have taken weeks, would have required Jane's family to sit through the detail of the allegations, and would not have changed his sentence by a day. What it changed was the record. Jane went to the police in November 2009 and spent the following 7 months building a case she had been told she would have to stand up and defend. She was killed to stop that case being heard. And then it was not heard. Jonathan Vass is not a convicted rapist. He is not on the sex offenders register. If he is ever released, and the earliest he could be considered is his 60s, none of the conditions that attach to a registered sex offender would attach to him. Her parents said at the time that this was the part they could not accept. Her father put it in terms of what Jane had already done. She had got out. She had gone to the police. She had agreed to give evidence. And the one thing she had asked the system for was a verdict on what he had done to her. In November 2010, the Clough family called publicly for the bail decision to be examined. They protested outside the court. They named the judge. On the 8th of November, the Judicial Communications Office issued a statement on his behalf. It said that whether to grant bail is a decision for the courts, within the framework Parliament set out in the Bail Act 1976. That the Act contains a general presumption in favour of bail, subject to defined exceptions. That at no stage was the judge told of any concerns Jane had expressed about her safety. That no evidence was presented to the court that Vass was likely to commit further offences against her. And then a final line. Vass, it said, was a paramedic of previous good character. Previous good character is a term of art. It means no relevant previous convictions, and that was accurate. It does not mean no history. Jane had been to the police about him before and had chosen not to proceed. His wife had reported him once, and that report was mentioned at the first hearing and not at the second. The Crown Prosecution Service gave a different account of what the judge had been told. It said it had informed the court that there was an extreme likelihood Vass would interfere with witnesses. For 18 months, those two statements sat against each other with no way to test either. Then the transcripts came out. In June 2011, a local newspaper, the Lancashire Telegraph, obtained a full written account of both hearings under the Freedom of Information Act. A formal application to the court service had been refused. The transcripts were released because Judge Newell personally agreed to release them. That is worth saying plainly. The man being criticised handed over the record. And the record supports both statements. The prosecution did object on the ground of witness interference. That is in the transcript. And the judge was never explicitly told that Vass might go on to offend against Jane. That is also in the transcript. Both accounts were true. They were answers to different questions. When John Clough read the transcripts, he said there had been no consideration given to Jane in either of them. He said he found it difficult to accept that the judge could claim not to know about her fears, and asked what anyone thought witness interference was supposed to mean, if not that. That is the argument. And it is a fair one. Nobody in that room thought Vass was going to telephone Jane and politely ask her to withdraw. But it was never said out loud, and the Bail Act does not run on what everybody in the room already knows. The family's campaign did not argue that the judge had broken the rules. The Judicial Communications Office had already said he had not, and on the face of the Bail Act that position is defensible. They argued something narrower and harder to refuse. Whatever the decision was, there should have been a way to test it. On the 28th of June 2011, 2 days before the transcripts were published, Andrew Stevenson, the Member of Parliament for Pendle, introduced a 10-minute rule bill to create one. John and Penny Clough sat in the public gallery. More than 50 MPs put their names to it. In January 2012, the Prime Minister told the Commons there was a strong case for the change, and that it would be attached to a bill already before Parliament. In February, the Cloughs were at the House of Lords to watch the amendment pass. It became Section 91 of the Legal Aid, Sentencing and Punishment of Offenders Act 2012. Where a judge of the Crown Court grants bail to a person charged with an imprisonable offence, the prosecution may now appeal to the High Court. It came into force on the 3rd of December 2012. In July that year, there was a second change, less noticed and arguably as significant. The Director of Public Prosecutions said that where an allegation as serious as rape sits behind a murder, the Crown Prosecution Service should press on with it. Leaving those counts to lie on the file, he said, should become the exception rather than the rule. That is a change in practice rather than in law, and it does not force any court to try anything. but it addresses the thing Jane's parents had been unable to get past. A man who kills the only witness to an allegation should not, by killing her, remove the allegation from the record. Under the guidance that now exists, the counts against Vass would have been pressed. Penny Clough was appointed MBE at the end of 2012. John Clough was appointed MBE in 2018. On his award he said he would rather be anonymous and still have his daughter. They ran the campaign for 9 years. They closed it in 2019. Two things did not change. The rape allegations were never tried. The change to prosecution practice came 2 years too late to reach them, and on the record they remain allegations. And the appeal right that came out of this case does not belong to the person it is named after. Section 91 gives the power to the prosecution. A complainant who thinks a bail decision has put her in danger still has no standing to challenge it. She can tell the police. The police can tell the Crown. The Crown can decide whether to appeal. But the decision remains theirs. Which leaves the question the whole case turns on. In December 2009 the prosecution had a door available to it and did not open it, because the fear it was carrying did not fit the box. If that happened again tomorrow, Section 91 would not help. There would be no appeal, because there would be nothing to appeal against. The objection would simply be filed in the wrong place a second time. She had written it down. She had told her family. She told the police in May that she was frightened, and said she would give evidence anyway. Everyone in that room understood what the danger was. Nobody was asked to say it.